an emergency. So these factors only cause the consequences of social inequalities and discrimination. So according to the 2011 data, there are around 10.1 million of child laborers, and 5.6 are boys and 4.5 millions are girls. And despite many organizations trying to protect the interest of the children, still the children are used as child laborers in various places. Like it can be, varieties of industries like brick kilns are there, crackers or carpet weaving, garment making, domestic service, food restaurants. You can also see them in tea stalls, small buddy shops, and agriculture, fisheries, and mining. So all these reasons have made it necessary that we need to have some kind of a protection act against children. So the country of India is home to a large number of children who are working illegally in various industries. And agriculture in India is the largest sector where most of the children in their early age groups, along with their families, they come and they work, and sometimes they work alone to support their families. So here, and according to ILO Convention number 182, the worst forms of child labor includes all form of slavery or practices similar to slavery, such as sale, trafficking children, debt bondage, and forced or compulsory labor, procuring or offering of a child for prostitution, or it can be the pornography or some kind of activities which actually indulge in showing the child for the illicit activities. And uh, this is where the milestone which has led to the enactment and the amendments of the Child Labor Prohibition and Regulation Act 1986 and the Declaration of the Rights of the Child in the year 1959. And the declaration includes that the child must be provided all the essential means which are important for the normal development of the child. And if a child is found to be hungry or sick, then the child must be fed and nursed. And if a child is backward or delinquent, the child must be helped and recovered. And if the child is an orphan or abandoned, then shelter should be provided to the child. And in the times of distress, relief must be provided to the children first. So this document was endorsed by the League of Nations General Assembly in the year 1924. So the International Convention of the Rights of the Child in the year 1989 is a human rights treaty that includes the rights of the children, which are related to civil and political and social health and cultural rights. So the nations which ratified the convention are bound to follow it under the international law, and the compliance of the same is checked by the UN Committee on the Rights. Now, coming to the rights of a child and the Indian Constitution, according to the Indian Constitution, the rights are ensured to the citizen of the country, and the children are also given rights under the Constitution. And as per that, the right to free elementary education that was made compulsory under Article 21, right to protection till age of 14 years from any kind of hazardous employment, and also the Constitution protects the children from any kind of abuse or forced employment, and the children are provided with equal opportunities, and Article 45 of the Constitution ensures early childhood care and education to the children. Now, apart from this, we also have the statutory provisions and child labor in India. So, the child labor legislation in India has traversed a long way since the 19th century, and it has set the minimum age of employment in factories at 7 years and allowed a maximum of 9 hours of work per week, per day. And it also provided that at least 4 holidays in a month and prohibited successive employment of child workers in two factories employing 100 or more workers. So here we see that they gave no protection to the children employed in smaller factories. So the Factories Act amended periodically, and through these amendments, the minimum age of employment of the child was increased gradually, and also the employment of children in the dangerous processes was prohibited. So according to that, the Indian government has prohibited the child to work below 13 years of age to work in certain categories of employment. And the Employment of Children Act 1938 was enacted, and the Employment of Children Act 1938 was the first act which directly addresses the problem. So, coming to the Minimum Wages Act, which was passed in the year 1948, defines a child to mean a person who had not completed 14 years of age, and it required that the appropriate government fixed different rates of wages for adults, adolescents, and children. So the normal working hours for a child being 4.5 hours, and no child is permitted to work overtime. So the Mines Act 1901 and the Indian Ports Act 1931, the Tea Districts Immigrants of Labor Act 1932. So all these acts have defined a child labor under different to identify as a child labor. There was no uniformity in the age. So in the year 1961, the Apprentices Act was passed and prohibited the apprenticeship training of a child below 14 years. And likewise, the Bonded Labor Systems Abolition and Regulation Act 1976, White Section 4, abolished the bonded labor system. Every bonded labor, including the child bonded labor, are free and discharged from any obligation to render any bonded labor. Now, coming to the observations and the recommendations of the commissions and the committee. So, there are various commissions and the committees which have been for the protection of the child labor. So, they have come up with several policies and several amendments in the act so that a child can be protected from the exploitation either by the employer or multiple employers. Now, the national policy for the children, which was in the year 1974, emphasize that no child below the age of 14 years would be permitted to be working in the dangerous work or allowed to do heavy work. So, and children would also be protected against the neglect, cruelty, and exploitation. And within the limitations of the availability of the natural resources, they would launch a time-bound program to educate the child, provide free and compulsory education to the children, so on and so forth. So the Committee on Child Labor, this is Gurupada Swami Committee, which was appointed by the Government of India, and in their report in the year 1979 recommended that a minimum age has to be fixed for the entry-level establishment and centering the enforcement machinery, establishment of child labor advisory boards, as well as formulation of effective education policy. And apart from that, we have the Child Labor Advisory Board with the minister, with the Labor Minister as the chairman was appointed in the year 1981. And the major functions of the board include to review the implementation of the existing laws, which are relating to the child labor, to suggest legislative and welfare measures for the working children, and also to review the process of welfare measures and to recommend industries where child labor should be eliminated. So coming to the enactment of the Child Labor Prohibition and the Regulation Act 1986. So as per this act, the focusing on the objectives, if we see prohibiting the employment of the children who has not completed the 14 years of age, prepare a procedure for changes in the schedule of banned jobs, hazardous jobs or heavy work should be prohibited, and controlling working conditions, do not prohibit children from working, and providing for enhanced fines for the employment of children in violation of the provisions, and get attractive in the definition of child in related rules. Now, coming to the scope and commencement, it repealed the earlier act on the child labor known as the Employment of Children Act 1938, and the provisions of this act shall come into force except for the part 3, and which shall come into the force on such date as the central government may by notification in the official gazette procure. Coming to the definitions, the appropriate governments, it means that an establishment under the control of the central government, or it can be the state government. A child is a person who has not completed his 14 years of age. Day means a period of 24 hours beginning at midnight. Establishment includes a shop, commercial or workshop, farm, residential, hotel. A family in relation to the occupier means the individual, the wife or the husband, as the case may be, and such individual and their children, brother or sister of such individual. Occupier in relation to an establishment or a workshop means the person who has the ultimate control over the affairs of the establishment or workshop. Port authority means any authority administering the port. Prescribed means prescribed by rules made under Section 18. Week means a period of 7 days beginning at the midnight of Saturday. Workshop can be any premises, including where the industrial process is carried out. Now, coming to the prohibition of employment of children in certain occupations. Now, occupations that are related to the transport of passengers, goods, or mails by railway. Uh, Cinder picking, clearing of an ash pit, or building operation in the railway premises, working in a catering establishment, and the occupation which involves work related to the construction of a railway station, any occupation within the limits of any port, working in slaughterhouses, the process involving making beady or carpet weaving, or it can be the cement or bagging of cement, cloth printing, dyeing, weaving, mica cutting and splitting, wool cleaning. Okay, so cashew and cashew nut descaling process, soldering processes in electronic industry. So these are the 13 occupations and 51 processes for the employment of children. Prohibits the employment, and Article 24 of the Indian Constitution includes that the provision for the prohibition of employment of children in the factories. So according to the Act, the employee cannot make a child employee work between 7 p.m. and 8 a.m. and no more overtime is allowed for them, and they cannot employ a child who is below 14 years. And uh, it is not allowed for an employer to make a child work for more than 3 years. So if he is appointed a child below 14 years, he is considered as a child labor. And 7 p.m. to 8 a.m., no overtime, and the child cannot be given for more than 3 hours without an interval of 1 hour. So these things should be kept in the mind whenever a child labor is employed. Now, power to amend the schedule, the central government, after giving by notification in the official gazette, not less than 3 months notice of its intention so to do, may be like notification, add any occupation, or they can add any processes to the schedule which shall be deemed to have been amended accordingly. So by notification, the central government might amend the number of occupations which can be considered as prohibited. And the Child Labor Technical Advisory Committee, the central government may, if it thinks fit, it can constitute a child advisory committee, and it is to be called the Child Labor Technical Advisory Committee. And by giving a notification in the official gazette to advise the central government for the purpose of addition of occupations, or it can be the addition of the processes to the existing schedule, and the committee shall consist of a chairman and such other members not exceeding 10 as may be appointed by the central government. So coming to the regulation of conditions of work for children. So there are certain regulations which are to be provided under this particular act, Child Labor and Prohibition Regulation Act 1986. And every employer should follow who employs child laborers in his establishment. So the provision of this part shall be applicable to an establishment or a class of establishments, so in which none of the occupations or processes are referred in section 3. So we have discussed just now, as per section 3, there are as many as 51 processes and as approximately 15 occupations where a child is prohibited to be employed. So apart from that, so there are certain rules. Now it comes to the hours and period of work. No child shall be required or permitted to work in any establishment excess of such number of hours as may be prescribed for the establishment. The period of work on each day shall be fixed, that no period shall exceed 3 hours and without an half an hour interval. And the period of work of a child shall be so arranged that inclusive of this interval, For the rest, no child shall be permitted to work between 7 p.m. to 8 a.m. No overtime is allowed for a child. And no child shall be required or permitted to work in any establishment on any day on which he has already been working in another establishment. So you cannot work with multiple employers. Coming to the weekly holidays, every child employed in an establishment shall be allowed in each week or holiday one whole day, which shall be specified by the occupier in a notice permanently, which is exhibited in the notice boards, which can be seen in such places. The notice has to be put up. And the notice to the inspector, every occupier in relation to an establishment in which a child was employed or permitted to work before the date of commencement of this act shall give a written notice containing the following particulars, that is the name and the situation of the establishment, the name of the person in actual management, the establishment is there, the address for the communication, and the nature of the occupation or process carried on in the establishment. So every occupier in relation to an establishment who employs or permits to work any child after the date of commencement of this act has to give these particulars in writing and follow the rules and regulations which are mentioned aforesaid regarding the working hours and holidays. Now, disputes as to the age, if any question arises between an inspector and the occupier as to the age of any child who has been employed or is permitted to work by him in the establishment. So, in the absence of a certificate which actually gives the details of the age, they can go to the prescribed medical authority, get the medical examination done, and based on the medical examination, whatever age has been mentioned, that would be the final age of the child. So the registers, whatever registers are there, records are there, they have to be maintained by the occupier, and the name of the date of birth of the child who are employed by the occupier, number of hours and period of work for which the child is employed, the nature of the employment, and other particulars as required should be maintained. And this has to be maintained in the notice containing the abstract of the sections 3 and 14. And the appropriate government by notification in the official gazette make rules of health and safety, cleanliness of the place, disposal of the waste, and ventilation, temperature, dust, and fume, device for cutting of the power, self-actuating machinery. So all these things they have to take care whenever a child is employed in the organization, and failing which that we have the penalties as per section 3, 20,000 rupees, 10,000 to 20,000 rupees, and 3 months to 1 year imprisonment, or both can be levied against the occupier. And whenever the having been convicted of an offense under section 3 commits a like offense afterwards, repetitive offense, then the imprisonment might be 6 months to 2 years. And if he fails to give notice as required by section 9, then he shall be imprisoned for 1 month with a fine which might extend up to rupees 10,000. So modified applications of certain laws in relation to the penalties. So based on the modifications, the following provisions which are mentioned here will be applicable and which will be considered relating to the offense. So any person, police officer or inspector may file a complaint to the commission of an offense. Every certificate as to the age of the child has been granted, and no court inferior to the metropolitan magistrate or a magistrate of the first class shall try any offense under the act. Now, the appropriate government may appoint inspectors for the purposes of securing, and they have the power to make rules. And this power to make rules is without any prejudice. I mean, against any particular person. So such rules will be provided in the following matters, namely the term office of the manner of the filling casual vacancies and the allowances payable to the chairman, number of hours for which a child may be required to work, grant of certificate of the age, and any other particulars which are registered maintained. And coming to the rules and notifications, every rule which is made by the government under this act and every notification which is issued under Section 4 shall be laid before each house of the parliament as soon as possible, and the rules and the notifications must be laid before the houses of the parliament if they are in session for a period of 30 days. And it may be comprised in one session or two sessions or successive sessions. And if both the houses agree jointly on a modification, that is made as a rule. And power to remove difficulties. If any difficulty arises in giving effect to the provisions of this act, the central government may by order publish in the official gazette and make the provisions which are not consistent. They can remove the inconsistent orders. And the Employment of the Children Act 1938 is hereby repealed, and also the amendments of the Act 11 of 1948 under Section 23. So this is based on the Minimum Wages Act 1948. So adolescent means a person who has completed his 14th year of age but not completed his 18th year. And an adult means a person who has completed his 18th year of age, and a child means a person who has not completed the age of 14 years. So whatever the amendments have been made, the amendments are pertaining to the child labor. So earlier, a child who has not attained 14 years is a child. Now that has been amended. Amendment of the Act 69 of 1951, which means that 15 will be substituted in the place of 14. And the amendment of Act of 44 of 1958, again here for the word 15, the word 14 shall be substituted in case of Merchant Shipping Act. And in the Motor Transport Workers Act 1961, 15, the word 14 shall be substituted. So based on the each categories of the workplaces, the definitions have been amended. Now, coming to the next subheading, it is relating to the sexual harassment of women at workplace, Prevention and Prohibition and Redressal Act 2013. So here we know that earlier days are gone where only men used to work. Now women equally work, equally they form a part of earning for the family, taking the burden of the family, and also in the workforce we see majority of women are coming out and working. And in this context we have to say women are facing several difficulties when it comes to sexual harassment at workplace, and gender discrimination, which is also there in the organizations, though our fundamental right to equality and right to life guarantee under the Articles 14, 15, and 21 of the Constitution of India, but still the workplace sexual harassment generally creates insecurity and hostile working environment for women, who and that will also hamper their ability to deliver the quality of work, or it can be the return of work to the organization. So here, if we see the international legislative frameworks are there, India's participation in the various international forums and the ratification of the international treaties on the human rights of women is a testimony of the commitment to ensure dignity and the equality of women in all spheres of life. So the Universal Declaration of Human Rights in the year 1948, which says that Articles 1, 2, and 7 speak out about the equality, dignity, rights and freedoms, and equal protection against any discrimination. And ILO Discrimination, Employment and Occupation Convention 1958, it also aims to protect against the discrimination in employment, occupation on the grounds of sex, race, color, religion. It can be political opinion, national or social origin. And apart from that, we also have the International Covenant on Economic, Social, Cultural Rights in the year 1966. It enjoins all the states to guarantee rights enunciated in it without any discrimination of any kind. So the states must have to ensure equality between women and men. So there is no gender discrimination. And this is for all the economic, social, and cultural rights which have been established in the covenant. And we also have United Nations Convention on the Elimination of All Forms of Discrimination Against Women. So Article 11 prescribes states to eliminate discrimination against women in the field of employment and also to ensure equality of men and women. So ILO Indigenous and Tribal People Conventions 1989. So the governments shall, within the framework of national laws and regulations, they have to, and in incorporation with people's concerned, adopt special measures to ensure that workers will be enjoying the equal opportunities. So ILO Decent Work for Domestic Workers Convention, here also each member shall take measures to ensure that domestic workers enjoy effective protection against all forms of abuse. And ILO resolution on equal opportunities and equal treatment for men and women in employment, it recommended that measures have to be taken to extend soil protection to women and men concerning reproductive hazards and sexual harassment. And the UN Declaration and the Elimination of Violence Against Women, in the year 1993, Article 1 of this declaration defined violence against women as the act of gender-based violence that results in physical or sexual or psychological harm or suffering to women. And the Beijing Platform of Action, it has drawn at the United Nations Women's Conference in Beijing, which call to advance women's rights and to eliminate violence against women, including sexual harassment at work. ILO HIV and AIDS recommendation, measures should be taken through the workplace to reduce the transmission of HIV and elevate its impact by ensuring actions to prevent and prohibit violence and harassment of women at the workplace. So we have in India, the Vishaka guidelines was the first ever legal action that provided a broad framework for preventing and addressing the cases of sexual harassment of work within the workplace, and the elimination of gender-based discrimination. So this is the famous judgment of Vishaka versus State of Rajasthan, wherein the Supreme Court framed certain guidelines and issued directions to the Union of India to enact an appropriate law for the combating workplace sexual harassment. So the POSH Act and the POSH rules were enacted 16 years after the Vishaka judgment. So what is Vishaka judgment? In the year 1992, Bhanwari Devi, a Dalit woman employed with the Rural Development Program of the government of Rajasthan, was brutally gang raped. And on account of her efforts to curb the prevalent practice of child marriage. So this incident has been revealed the hazards that working women were exposed on a day-to-day basis. So highlighting the urgency to safeguard and implement some measures wherein you can protect the woman at workplace. So during this case that the Supreme Court has come up with the various legislative inadequacies and acknowledged workplace sexual harassment as human rights violation. And certain points have been given by the Supreme Court by observing the Vishaka's case. So sexual harassment can be in the following manner. It can be the physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. So these all come under the sexual advances. So post Vishaka, there are some other judgments also. We have Apparel Export Promotion Council versus AK Chopra. So the same thing, the Vishaka judgment, which has initiated the workplace sexual harassment throughout the wide open, an issue that was swept under the carpet for the longest time. So here we can see that In this particular case, the Supreme Court reiterated the law laid down in the Vishaka judgment and upheld the dismissal of superior officer of the Delhi-based Apparel Export Promotion Council, who was found guilty of sexually harassing a subordinate female employee at the workplace. So we like that we have so many cases which have come up with unique judgments which were to protect the women employees and protecting their identity and protecting their rights. So that is what the Supreme Court judgments have taken place. So these are the so many cases wherein the judgment were given in favor of women employees against sexual harassment. Now coming to the enactment of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So as per this government, they would be providing protection against sexual harassment of women at workplace, and sexual harassment results in the violation of the fundamental rights of a woman to equality under the articles 14 and 5 of the constitution, and the right to live and to live with dignity under article 21. So this act is going to protect the women against any kind of discrimination and the sexual harassment at the workplace. So the Prevention of Sexual Harassment, POSH, which was introduced by the Supreme Court of India, and it was reported by the ILO that very few Indian employers were complained to this statute. Most Indian employers have not implemented the law despite there is a legal requirement. Coming to the scope and applicability of this particular act, so it applies, it extends to whole of India, and it came to force on such date which has been prescribed by the central government in the year 2013. Now, who is an aggrieved woman? In relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subject to any sexual harassment, and in relation to dwelling place or house, a woman of any age who is employed in such a dwelling place or house. Now, the appropriate government can be the central government, or it applies to the state government, or it applies to the territory where the union territory administration is by the central government. The chairperson means the chairperson of the local complaints committee nominated under subsection 1 of section 7, district officer who is notified under section 5. Domestic worker means a woman who is employed to do the household work in any household for the remuneration. Employee means a person employed at a workplace for any work on regular or temporary or ad hoc or daily wages basis. And then we have employer. It can be in relation to department, organization, undertaking, establishment, or enterprise, institute, office, or any other place, or in any workplace not covered under the above, any person responsible for the management and supervision and control of the workplace. And in relation to a dwelling place or house, a person or a household who employs such person. Now, internal committee means an internal complaints committee constituted under section 4, local committee, complaints committee constituted under section 6. A member means a member of the internal committee, prescribed rules which are made under this act. Presiding officer of the internal complaints committee nominated under section 4, subsection 2. Respondent means a person against whom the agreed woman has made a complaint under the under section 9. Sexual harassment, as we have already defined in the earlier case, the meaning remains the same. And the workplace remains the department or organization, private sector, hospitals or nursing homes, sports institutions, stadiums, or any place visited by employee in the course of the employment or dwelling place or a house. Unorganized sector, a workplace which means an enterprise owned by an individuals or self-employed workers, and they are engaged in the production and the sale of the goods providing. Now, coming to the sexual harassment meaning and forms. It is on the basis of sex that has the purpose of effect of substantiality interfering with a person's work performance or creating an intimidating, hostile or offensive work environment. So it can be submission to such conduct is made either explicitly or implicitly. Submission or rejection of such conduct by an individual is used on the basis of the decisions affecting that individual. Such conduct has the purpose or effect unreasonably transferring with an individual's work performance. Coming to the forms of sexual harassment, quid pro quo. This form of harassment is the exchange of sexual favors for the job benefits. Hostile environment created by the supervisors. This is to create an offensive working environment. Hostile environment created by co-workers or non-employees. Uh, so, this is for an employee without direct harassment by supervisors, and this can be through the employees or co-workers. So the basic objectives of the act is the sexual harassment at the workplace is considered a violation of women's right to equality, life and liberty. And this such environment will create a hostile environment, insecure environment, and which discourages the woman in the participation in the performance. So here, how do we prevent the sexual harassment? No woman shall be subject to sexual harassment at any workplace. The following circumstances, among other circumstances, if it occurs or present in relation, shall be considered as sexual harassment, such as implied or explicit profit, promise of preferential treatment, implied or explicit threat of detrimental treatment, or it can be about her present or future employment status, interference with her work, or creating intimidating or offensive or hostile work environment, humiliating treatment like to affect her health and safety. So coming to the constitution of Internal Compliance Committee. So we have the two main committees, Internal Compliance Committee and Local Compliance Committee. So the constitution says that every employer of a workplace shall be by order in writing constitute a committee to be known as Internal Compliance Committee. And this provides where the it shall consist of the members which have been nominated by the employer. You have a presiding officer, generally who shall be a woman employed at a senior level at workplace, and not less than two members from the employees, preferably committed to the cause of women, and one member from the amongst should be the non-governmental organization or association committed to the cause of a woman or a person familiar. And coming to the constitution of Local Complaints Committee, the Act provides that the following provisions relating to the constitution. The first is notification of district officer. The appropriate government may notify a district magistrate or additional district magistrate or the collector to exercise the powers or discharge functions under this act. Now, coming to the constitution and jurisdiction, local committee, they generally receive the complaints of sexual harassments from the establishments, and the district officer shall designate one nodal officer in every block or taluka or tehsil in the rural or tribal area, and the complaints within a period of 7 days, they have to receive the complaints and forward the same to the concerned local committee. And the jurisdiction of the local committee shall be extend to the areas of the districts where it is constituted. Now, coming to the tenure, the chairperson will be nominated amongst the eminent women in the field of social work. One member to be nominated from amongst the women working in block, taluka, or tehsil, two members of whom at least one shall be a woman to be nominated from among such non-governmental organizations. And the concerned officer dealing with the social welfare or women and the child development in the district shall be the member of ex officio. And the chairperson and every member of the local committee shall hold office for such period not exceeding 3 years from the date of the appointment. And here, the grants and audit, the central government may, after due appropriations made by the parliament, by law in this behalf, make to the state government grants of such sums of money as the central government may think fit. And the state government may set up an agency and transfer the grants made under the subsection, and the agency shall pay to the district officer, and the accounts of the agency referred under subsection 2 will be maintained and audited in such a manner by the appropriate Accountant General of the state. Now, coming to the complaint mechanism, lodging a complaint against sexual harassment is an important and crucial activity under this Act. So, any aggrieved woman may, like in writing, a complaint of sexual harassment at workplace to the internal committee, if so constituted, and if there is no internal committee, then to the local committee. In case if it is not constituted within a period of 3 months from the date of the incident, in case of series of incidents within a period of 3 months from the date of last incident. If such complaint cannot be made in writing, the presiding officer or any member of the internal committee or the chairman or the member or the local committee shall render all reasonable assistance to the woman for making the complaint in writing. And once the reasons have to be recorded in writing in the not exceeding 3 months, and if it is satisfied that the circumstances were such which prevented the woman from filing a complaint within the set period, then the extension can be given where the agreed woman is unstable to make a complaint on account of her physical or mental incapacity or death, or otherwise her legal heir or such other person may be prescribed, may make a complaint under this particular section. So you can solve the problem through conciliation process, settle the matters which can be initiated between the parties. And this can be done only upon the request of the aggrieved woman on this behalf. And once the complaint has been made, inquiry into the complaint has to be done. So the inquiry includes summoning the attendance, discovery of the production of documents or any other matter which will be prescribed. And coming to the action during the pendency period, when any case is withheld under the internal committee or local committee, as the case may recommend to the employer to transfer the agreed woman or the respondent to any other workplace, or grant leave to the agreed woman for a period up to 3 months, or grant such other relief to the agreed woman as may be prescribed. Now, once the inquiry done, the inquiry report will be prepared by the internal committee or the local committee, and it shall provide a report of its findings to the employer, and they might arrive at a conclusion that the allegation against the respondent has not been proved. It shall recommend to the employer and the district officer that no action is required to be taken in the matter. And if the committee comes to a conclusion that the allegation against the respondent have been proved, it might give the following recommendations: to take action for the sexual harassment or a misconduct, or to deduct withstanding anything in the service rules applicable to the respondent from the salary of the wages, and such sum may be considered appropriate to be paid to the aggrieved woman or to his legal heirs. Now, coming to the punishment for false or malicious complaint and false evidence. So, whenever a woman or any other person making a complaint which is not true, false or misleading, it may recommend to employer, district officer to take action against the complaint as prescribed by the Act. Now, coming to the determination of compensation, it depends upon the mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman, loss of career opportunity due to the incident of sexual harassment, medical expenses incurred by the victim for physical or psychiatric treatment, the income and financial status of the respondent, and the feasibility of such payment in lump sum or in installments. And prohibition of publication or making known contents of complaint and inquiry proceedings. So the statute specifically stipulates that the information pertaining to workplace sexual harassment shall not be subject to the provisions of the Right to Information Act 2005. And it also prohibits the dissemination of the contents of the complaint or the identity and the addresses of the complaint. Now, penalty for the publication. So, if anything goes wrong, there's a penalty which will be levied for publication of the inquiry or the proceedings. And there is also an appeal. Within 90 days of such thing, the appeal has to be made to the tribunal. And based on that, the recommendations will be given. The duties of the employer: it should provide safe working environment to the women employees, display in the workplace the penal consequences of the sexual harassments, organize workshops and awareness programs, and also provide necessary facilities to the internal committees and the local committees, and assist in securing the attendance of the respondent and witness before the internal committee, and also treat sexual harassment as a misconduct, and monitor the timely submission of the reports to the internal committee. So they are due to the district officer who will be monitoring the local committee against sexual harassment uh, against the woman. And they also submit annual report pertaining to the various dealings in the calendar year and submit the same to the employer as well as the district officer. So employer should include all the information pertaining to the things which have actually happened in the organization during that period. And the appropriate government shall monitor the implementation of the Sexual Harassment Act and see that there is proper protection for the women employees who are working in the organization. And the appropriate government have power to call for the inspection, record the inspection of the records, and there is also a penalty for the non-compliance of these provisions, and the penalty would be up to rupees 50,000, and for the subsequent offences twice the punishment might be levied against the person. Now coming to the cognizance, no court inferior to the metropolitan magistrate or a judicial magistrate of the first class shall try an offence, and the power of the appropriate government to make rules vests with the central government by notification in the official gazette, might carry out the power of making the rules, and they also have the power to remove the difficulties. So whenever the rules are not consistent, there is inconsistency in the provisions which will hinder the performance, then it also has the power to remove the difficulties. And coming to the country's legal approaches on sexual harassment, we see that in South Africa or in any other cases, we see these are the things which are being followed. Equal opportunities laws are there, criminal laws are there, tort laws are there, and also the labor laws. These are the laws which have been made in different countries wherein they try to provide the reduction of the gender discrimination and protection of women against sexual harassment. So there are anti-sexual harassment laws and guidelines in India which will be followed as per the constitutional provisions. We have Article 15, Article 39, A, D, E, and Article 42 and 51, which actually have the constitutional provisions which protect against the sexual harassment. And as well as we have the legal provisions for the working woman, we have the Indian Penal Code as well as the Factories Act 1948, the Maternity Benefit Act 1961, and the Equal Remuneration Act. So all these acts have been envisaged in the protection of female or women employees at the workplace. Now, coming to the next subheading, which deals with the Information Technology Act 2000. Now, this information technology is nothing but using computers and internet for the communication and for the recording and for the presentation of the data. So by now we see that the scenario has changed. Now no longer we use books or records for completion of the data. We use the information technology, latest systems and upgraded versions for the presentation and the transfer of the communication to the required people. Now, due to globalization and vast technical changes have occurred in all types of industry, and majority of the human resources, including the workers, whether directly or indirectly, they depend upon the information technology irrespective of their designations. So IT is dominating. It has become a part of personal and professional life. And moreover, we are using information technology at workplace. And for that purposes, we need to understand the information technology. We have to take correct, right, proper action against the personnel. On one side of the technology, it is providing high leverage to the organizations. And on the other side, if we see the worker misused it when the company needs to face huge damages. Hence, in the modern era, the information technology is knowing relevant IT Act will enable HR to take proper action against them. Now, coming to the Information Technology Act 2000, the basic objectives of this particular act are: it provides legal recognitions to the transactions done via electronic exchange of data and other electronic means of communication or electronic commerce transactions. So, grant legal recognition to all transactions done via electronic exchanges, give legal recognition to digital signatures, facilitate the electronic filing of the documents, facilitate the electronic storage of data, give legal sanction, grant legal recognition, so on and so forth are the objectives. And coming to the structure of the Act totally has 13 chapters and 90 sections. And section 91 to 94 in the IT Act 2000 dealt with the amendments to the four acts, namely the Indian Penal Code 1860. Now, coming to the Information Technology Amendment Act 2008, being the first legislation in the nation on technology, computers, and e-commerce, the act was subject to certain extensive debates and elaborative reviews and detailed criticisms. So there were some conspicuous omissions too, resulting in the investigators relying more and more on the time-tested Indian Penal Code, even in technology-based cases, with the IT Act, Information Technology Amendment Act 2008 was placed in the Parliament. So this Amendment Act got the President accent on 5th Feb 2009, and it was effective from 27th of October 2009. So changes in the amendment include redefining term as communication device to reflect current use, validating electronic signatures and contracts, making the owner of a given IP address responsible for content accessed or distributed through it, and making corporations responsible for implementing effective data security practices and liable for breaches. So as per this, there are a few definitions. Access, it means with the grammatical variations, and cognate expressions means gaining entry into, instructing, or communicating with the logical, arithmetical, or memory function resources of a computer. Addressee means a person who is intended by the originator to receive the electronic record. Affixing, electronic signature. And then we have communication device. It means cell phones, personal digital assistants, or combination of both. Computer system means a device or collection of devices. Cyber cafe means any facility from where the access to the internet is offered. Cyber security means protecting information, equipment, devices, computer resources, communication from unauthorized access. Data means a representation of information, knowledge, facts, and concepts. Digital signature means authentication of any electronic record by a subscriber. Electronic record means data, record or data generated, image or sound, tone received through electronic form. Electronic signature means it is an authentication of any electronic record by a subscriber by means of an electronic technique. Information includes data, message, text, image, voice, sound, codes, computer programs. Originator means a person who sends, generates, stores, or transmits any electronic message. Private key means the key of a key pair used to create a digital signature. Public key means the key of a key pair used to verify a digital signature. Secure system means it can be a computer hardware, software. And security procedure means which is prescribed under Section 16 by the central government. Subscriber is a person whose name the electronic signature certificate is issued. Now, coming to the digital signature, which was defined in ITAA, Information Technology Amendment Act 2008. Digital signature was defined as an authentication of electronic record as a procedure laid down in Section 3. And it is a public key infrastructure and a hash function. And this can be used for the digital or e-commerce or any other facilities in the transaction. Now, electronic signature is not the process of storing one signature or scanning one signature or sending it an electronic communication like email. It is a process of authentication of whatever the message using the procedure laid down in Section 3 of the Act. Now, e-governance, there's a legal recognition of record where any law requires that any information should be in the type of a written or printed form, then such requirement shall be deemed to be satisfied. We also have legal recognition of electronic signatures where any law provides that only information or other matters shall be authenticated by affixing the signature on the document. Use of electronic records and electronic signatures in the government agencies, or it can be the delivery of services by the service provider, or retention of the electronic records whenever the audit of the documents and the maintained in the electronic form wherein such signature can be acceptable, and publication of rule regulation in the electronic gazette. And there is no right to insist government office to interact in the electronic form. You cannot, no right is conferred upon any person to insist any ministry of department of central government or state government or any other authority to accept, issue, create, retain, preserve any documents in the form of electronic records. And the power to make rules vests with the central government. Now, the attribution of the electronic records shall be or to the originator if it was sent by the originator by himself or by a person who has the authority to act on his behalf, or by an information system program on behalf of the originator. So acknowledgement of receipt, any communication by the addressee, automated or otherwise, or any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received. So this is called as an acknowledgement of receipt. Now coming to the time and place of dispatch and receipt of electronic board. So once there's a save as otherwise agreed in between the originator and the addressee, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator, and it receives the addressee which has been entered, and it is sent through a computer resource. And if the addressee has not designated a computer resource along with the specific time, then the receipt might occur when the electronic record enters the computer resource by the addressee. If you don't mention the time, so whatever time it receives, it can be considered. And for the purpose of this section, if the originator or the addressee has more than one place of business, the principal place of business will be considered. If the originator or the addressee does not have any place of business, his usual place will be considered. That is, it can be a residence. Usual place of residence in relation to a body corporate means the place where it is registered. Now, the security procedure has been applied to all the electronic record at a specified point and specific time. So you need to secure the electronic signature because the signature creation, date, data at the time of affixing the signature, and whatever is deemed to be there, that should be secure electronic signature. And security procedures and practices, the central government may, for the purpose of this sections 14 and 15, prescribe the security procedures and practices. So secure digital signature. Now, the application of a security procedure, it has to be agreed by the parties concerned, and it can be verified by that is digital signature at the time it was affixed, unique to the subscriber affixing it, capable of identifying such subscriber, created in a manner or using a means under the exclusive control of the subscriber. So digital signatures are the most advanced and secure type of electronic signatures. So it can be verified that a digital signature at the time it was affixed was unique, capable of identifying, created in a manner. Now coming to the difference between digital signature and electronic signature. Electronic signatures or e-signatures refer broadly to any electronic process that indicates acceptance of an agreement or a record. And the digital signature is frequently used to refer to one specific type of electronic signature. Now, the typical electronic signature solution uses comma, electronic authentication methods to verify signer identity. It can be email, corporate IDs. And the best part of the e-signature solutions demonstrate a proof of signing using a secure process. And signature types are linked with the signature laws and regulatory requirements. So they are certifying authorities. The Office of the Controller of Certifying Authorities issues a certificate only to certifying authorities. So they will be certifying authorities which are called as CA, and they have the power to certify the digital signatures. So if you can just see, these are the certified authorities and their websites wherein they can certify the signatures. To certifying authority to issue electronic signature certificate. So any person who can make an application to the certifying authority for the use of electronic signature should apply in the prescribed form, may be prescribed by the central government, and every such application shall be accompanied by a fee not exceeding 25,000 rupees, which is prescribed by central government, and every such application will also be accompanying a certification practice statement that there is no such statement containing the particulars. And on the receipt of an application, the certifying authority may, after considering, may provide the certification. So coming to the representations upon issuance of digital signature. So here, the subscriber holds the private key corresponding to the public key listed in the digital signature. The subscriber's public key and private key constitute a functioning key pair, and the information contained in the digital signature certificate is accurate. And the suspension of digital signature certificate, it can also be suspended. So on the receipt of the request from the subscriber listed in the digital signature certificate, or it can be from the person authorized, will be suspended in the public interest. And the digital signature certificate shall not be suspended for a period exceeding 15 days unless the subscriber has been given an opportunity of being heard. Now, revocation of digital signature certificate, where any subscriber in person makes a request upon the death of the subscriber or upon the dissolution, the revocation of the digital signature certificate may also be taken. Now, the notice of the suspension or revocation can be given under section 37, 38. The certifying authority shall publish a notice of such suspension or revocation as the case may be. And the penalty and compensation for damage of computer or computer system, if any person without permission of the owner or any other person who is in charge of a computer introduces or causes the contamination of the computer virus, damages or causes damages to any computer, disrupts of any computer, disruption, denies the access to any person authorized, charges the services availed by a person, destroys or deletes or alters the information, steals or conceals or anything, the code or some important information of the computer will be legally punished. So compensation for the protection to protect the data. So there is also compensation which is provided due to the negligence wherein the data has been lost for the by any of the person. So for the wrongful loss or the wrongful gain to any person, such body corporate shall be liable to pay damages. Now, penalty to for failure to furnish the information return. So there is also penalty which might be exceeding up to 1 lakh and 50,000 rupees. And they file any return for the furnish of any information, books or other documents within the time specified, and maintain the books of accounts. And the residuary penalty, whoever contravenes any rules or regulations made under this act for the contravention, of which no penalty has been separately provided, shall be liable to pay a compensation not exceeding 25,000 rupees to the person affected. So power to educate, the adjudicating, the judging under this chapter, any person has committed a contravention of any act of the provisions might, which allows him to make the penalty or the compensation. The central government shall, subject to the provisions, may appoint any officer not below the rank of director to the government of India to verify the facts. So the factors to be taken into account by the adjudicating officer, the amount of gain of unfair advantage, the amount of loss caused by any person. So tampering with the computer sources and the documents, computer-related offenses, punishment for sending offensive messages through emails or any electronic devices, punishment for the dishonesty, receiving stolen computer, buying stolen computer or buying the information, punishment for the identity theft, punishment for cheating. There is also punishment for violation of privacy and punishment for the cyber terrorism. So these are the different levels of punishments which are levied, and there is also a penalty which might extend up to 1 lakh to 10 lakh rupees, and as well as there's an imprisonment up to 5 years. So in either case, if the person is proved guilty, the fine and the penalty will be levied to protect the interest of the persons. Now, the power of controller to give directions as and when possible to identify the guilty and to compensate the person who has actually incurred losses is left with the controller, and he has the directions to give the to direct the certifying authority or any employee of such authority to take measures and also seize the activities which are specified in the order. So we have the protected system, the appropriate government by notification to the official gazette, declare any computer resource which directly or indirectly affects the facility, the critical information. There is also penalty for misrepresentation, which can be up to 1 lakh rupees or 2 years imprisonment, penalty for the breach of confidentiality. And for everything, you might have the fine up to rupees 1 lakh and an imprisonment, which might extend up to 2 years. So here there is also confiscation. Any computer system or floppies or compact discs or tapes which have been found, which are being identified as misuse can be confiscated as well. So the central government to notify the examiner of the electronic devices for the purpose of providing expert opinion on the electronic form evidence before the court of the authority. And the government also has the power of police officer and other officers to enter and search for any data or information. So this is how we have the IPC code, Criminal Procedure 1973, the rank of an inspector or who has been the officer of the central government or the state government has the power to take reasonable action against such discriminations. So this is what all about the Information Technology Act. So thank you. I stop here.